Welcome back everyone. So I want to look at consideration and intention to create legal relations. So I've got a presentation ready. I'm just going to go full screen. So as we're sort of tracing our journey in contract law, the first couple of topics are really looking at whether or not, a contract actually exists, and what you need to be aware of is, what you need to be aware of are the essential elements of a contract. So that would be offer, acceptance, consideration, and intention to create legal relations. And so the focus of the video today is going to be on the last two, consideration and intention to create legal relations. So at the starting point for consideration, the questions I ask my class are, what is consideration in a contract? Now, there are, depending on the resource you use, a number of definitions, but it's essentially what each party promises to put into a contract. So what form can consideration take? And again, there are many forms here. It can be money, goods, services, and even a promise to do or not to do something. Although, as we're going to see, perhaps the case law precedent regarding promises can be a little bit inconsistent at times. Two more sort of key terms here. What does the term executed mean, and what does the term executory mean? And you can see there that the first is where consideration has been performed, so it's the past tense, and then with the latter it's where it's yet to be performed. So we really want to try and sort of get used to using these key terms. I think previously we've got offeree, offeror, or the other way around I should say. Offeror is the person making the offer, offeree is the person receiving that offer, and these are two more to add to our glossary. So not everyone necessarily may realise this, but I dug up this sort of news story here in the UK. This goes back to 2016, but you can find other examples. And Homebase, which is, for those who don't know, a retailer in this country that sort of sells a number of things: garden, plants, furniture, home DIY, and so on and so forth. They've gone through various ownership, and this story here picks up on the Homebase owner selling Homebase it's selling it up for £1 after the most disastrous retail deal ever. So I sort of asked my students here, why is it that a business can be sold for £1? Because on face value that just seems illogical. Could the business have been sold for free? And this really goes to the heart of what consideration is, and is recognised by English law. Firstly, what we need to be mindful of is that when we talk about consideration, perhaps the exchange of both parties putting something into the contract, could be exchange of promises, for example, or money for goods. It doesn't need to be adequate. In other words, it doesn't have to be of the exact value, and that's what this news story really represents. Because clearly, Homebase, a big business, a big brand, many sort of outlets across the UK, is clearly worth more than £1. Although it's interesting to note that whoever did purchase this or goes on to, any debts and so forth will also they'll have to bear as well. So it's really almost like a tokenistic gesture, this £1. So it doesn't have to be the exact value, but the second point is it certainly must be sufficient. And what we mean here is it has to have some value, and that is why in contract law you cannot have something given away for nothing, something for free, because if we go back to our definition, only one party is putting something into a contract and the other party isn't, and is expecting therefore to receive, in this case, a business for free, and it just won't be legally recognised. I mean, that's a gift, isn't it? That's not a legally binding contract. We also need to be aware of, and of course the exam questions that we have in AQA do like to throw this in, what does past consideration mean? And that's consideration that cannot be an act that has already been performed. So we're going to look at an example of this shortly, but as I said, consideration is what the parties, or let's say two parties, are putting into a contract. So for example, If I want to buy a car from somebody, then I may very well, the person saying you can buy my car for, I don't know, £800, second-hand car. I put money in, which is the £800. They, put the car into the contract, and that's the exchange. But one party or more parties cannot put something into a contract that has already been performed, and we're going to see examples of this. And the reason being is whatever consideration has to be, we know just now that it need not be adequate, it has to be sufficient, it certainly has to be fresh. So, each party has to put something in, something yet to be performed. So the key cases I'd like to highlight, there are many, but I've kind of narrowed it down to these, is the Chappell and Nestle company case. And as you can see the picture clues there, this involved the chocolate company. Nestle ran a sales promotion where if you sent in 3 chocolate bar wrappers, and along with, I think, covering postage and packaging, you could actually purchase a special promotional LP. I think it was a vinyl recording. Now, less interesting perhaps for what we're doing today in terms of how this dispute reached the court. It was actually a copyright issue by the owner of one of the pieces of music on one of the promotional LPs. That was what brought it to court. But the question that was discussed was this a contract? Was this consideration chocolate bar wrappers by the consumer sending them in with the postage and packaging money to get this LP? Was this a contractual situation in terms of goods? And the answer is, well, yes, because as we said before, consideration doesn't need to be adequate. In other words, it doesn't need to be of the exact value. Now, clearly, these LP, these records, these vinyls were worth more than 3 chocolate wrappers. I mean, to be honest with you, you just probably throw them in the bin, wouldn't you? But because they had some value because of this promotion, the courts accepted that they were. Ward and Byam, involving a child. We've got here, Ward had a daughter out of wedlock, later ending the relationship. The father agreed to have the daughter live with the mother and pay her £1 a week, provided she look after the child and make sure she was happy. I should just say, with many of these cases, as you're perhaps looking them up with me, they are in contract law certainly very old. So if you're thinking £1 a week is quite a good deal, I think take into account what that value would be, in terms of today. When she remarried, he stopped payments, which led to the dispute. So I guess here the question is, could a promise by, in this case I think it's the mother, isn't it, to look after the child, make that child happy, and meet its every needs, emotionally, financially and so on, was that, a promise? And therefore amounting to consideration. And the court said a promise to look after a child is good consideration. Now, perhaps why the courts felt this is because it went over and above what a typical promise would be. Perhaps they also felt that, children, vulnerable young people as they are, again, this was something that should be considered good consideration as part of the contract. But we can compare and contrast that somewhat with the next case, White and Blewett. And in this case, you've got here that Blewett Jr. was lent money by his father. When he died before he could repay it, White, who executed the will, so basically performed it, sued him for the outstanding money. Now, Blewett said he had agreed with his father before his death to accept the money that was given to him, provided, and this was the promise, he stopped complaining about potentially how the father was going to split the estate and who would receive what money and so forth. So that was the promise. Was this enough to amount to good consideration, a promise not to complain in essence? And no, it wasn't considered good consideration. So we can already see the law is slightly inconsistent here. But in terms of A-level that we're doing and exam questions, a promise to a child would be sufficient. Now we have three others, and the next one is very crucial, of course, because it ties into the issue of past consideration, which, if you remember, we said just a short time ago, is not good consideration, is never accepted as valid consideration to form a legally binding contract. Re McArdle, facts were as follows. McArdle left a house to his widow, and when he died, left the house, to her to live in, and they had, of course, their 5 children. And I think it was meant to be that certainly when the wife would then pass away, that the house would be split up, the value of the house would be divided amongst the 5 children. Now, this is the point at which the wife of one of his sons decided to carry out various home improvements while the widow, I think, lived there, and it amounted to £488, and she paid that herself. And then she sought to get an agreement signed, by all the other sons to basically say in this document, when the mother does pass on and the house is sold and the money is looking to be split, that you will repay me for all of the redecorating and home improvements that have been done. And it didn't work. The courts weren't prepared to accept that because, as I said, past consideration is not allowed. She had already, at the point she was, trying to seek agreement for a contract with the sons, she had already done what she was proposing to put into the contract. So, if she said something like, if I decorate the house, can I have your agreement signed that when the house is split and the value of it, is dealt out, can I then have, the money or the equivalent of what the home improvements were? And that would have been fine because, she'd still had yet to do it. But because she'd already performed this, she's putting nothing new or fresh into the contract. In essence, only the sons are, by saying, we'll pay you when the time comes. Lampley and Braithwaite, interesting case, one of the oldest certainly that we deal with. I think it was around about the 1600s. And there again, you've got to look out for this in exam scenarios, but what we have here is Braithwaite killed a man, was due to be hanged for murder. He asked Lampley to get a pardon from the king, so essentially, a royal pardon, a document which would have saved his life. And of course Braithwaite promised to pay him, but then when he got the pardon and he escaped this murder charge and the death penalty, then chose not to do it, and that's why it went to court. I'm not sure exactly, but certainly pardons which could be paid for, sought from the king, they were by no means cheap. And what the courts said here when they decided it was, a promise for future payment is good consideration. So we're looking at problem scenarios where one party does something, perhaps something quite significant for the other, and we could say perhaps it's implied, it's not expressly said, but it's implied that that party's going to expect some kind of consideration in return, be it money, whatever it may be. Here it was quite of an express promise. I promised to pay you, and then suddenly didn't. So yeah, a promise for future payment, and then going back over on the deal, the courts won't like that one little bit. And in DC Builders and Rees, DC Builders accepted £300 under pressure of their business failing to satisfy an outstanding debt that Rees owed them of £482. So here the builders, as I say, thought it's better to get some money from Rees than none at all, because they were in financial pressure. And then once they received the £300, they then went to court and sued Rees for the outstanding amount. And of course Rees would argue, well, you said that would settle it, so we had consideration, didn't we? I gave you the money, you said that's fine. Ratio, interestingly, promise of part payment of an existing debt, which is what we see here, only part payment of an existing debt, to get rid of the full debt is not good consideration, so will not be acceptable by the courts. even if DC Builders said at the time, yeah, that's fine, if they then change their mind to sue, then they have a right. There's a few exceptions, I think, on the next part about this. Just really something to look out for. An agreement to accept an earlier payment of a smaller sum than the whole debt. An agreement to accept something other than money instead of the debt. So perhaps party may not have any money, but they're offering, their own property, such as, here's my car, does that cover the debt that you owe me? And thirdly, an agreement to accept a part payment together with something else, not to the value of that debt. So this is, complicated-ish to remember, but I think it's just something to look out for, certainly, when you look at your problem scenarios. Again, here, I might go back to this another time in a bit more detail, but I'm just going to flag it up here and say that there is a doctrine, when I say doctrine, I mean sort of like an idea, a concept, called Promissory Estoppel. And this is the idea in contract law that, as it says there, where one party to a contract promises to do something and then they don't, a bit similar to the case we just did with Lampley and Braithwaite and the promise to pay for that pardon that the person got but didn't get paid for, then there is this court action of promissory estoppel to enforce that promise, to make the court force the promise to be performed. And it's certainly a way of stopping someone from going back over their word, which is, as I put there, only fair. Okay, as ever, got some scenarios here. If you would like to pause the video and try these yourself, by all means do. And the question here is in each, is there consideration, or is it past consideration, or is it no consideration? And again, I suppose if it were past consideration, it would be no consideration anyway. So if you want to pause the video, by all means, I'm going to go through these now. So the first is, while away on holiday abroad for a week, I ask my neighbour to water my garden. I thank her when I return, and I say I will give her £10 to show my appreciation. However, I don't give her the money. So the dispute arises there. Will the courts force me to do that? Is that consideration? Let's have a look. It's past consideration. So I'd be citing the Re-McArdle case, which we talked about earlier, regarding the wife of one of the sons who did home improvements and decorated the place for £488, and then tried to get the sons to sign a document to reimburse her when the property would be sold later. Why is this past consideration? Because she's already, I should say, the neighbour has already watered your garden. So when you return after the fact of the garden being watered and say you'll give £10, that's consideration, money, you're not putting, or rather the neighbour is not putting anything fresh into the contract because they've already watered the garden. Second one, having broken my leg in a freak accident, I arranged with a colleague from college to give me a lift to and from the place each day. I agree to cover any costs regarding petrol each week, and then later refuse to pay. So I don't know if you got this one right either, but let's see. Consideration in this case, this looks like the Lampley and Braithwaite precedent kicks in, because arranging with a colleague to give a lift, and there's an express promise there to cover any costs, and then of course I go back on my word. So yeah, Lampley and Braithwaite, the courts will accept that as good consideration, and I should pay up. Thirdly, a friend buys me a second-hand car for my birthday. I tell them I will give the money back to them as soon as I can, but I don't. We had many discussion about this in class, but I mean ultimately I was heading towards no consideration, because I think this is just simply a gift. And I don't know about any of you watching and listening to this, but sometimes there might be a situation where somebody surprises you with a gift. Perhaps it's an expensive one, and I think out of politeness and such, you might say, oh, you shouldn't have done that, and you might say, oh, I will pay you back, or whatever it might be, and invariably that doesn't really tend to happen. So I think because the nature of this here is a gift, that's how the courts would see it, and it's going to tie in as well, if anyone was thinking of suing, to the last bit, which is intention to create legal relations. So we'll touch on that in a minute. Fourthly, I come across an injured person and help them to their house. They thank me and promise to buy me lunch, and we swap details. However, they don't contact me again. This again is past consideration, because you've helped that person, you've performed, that action. Then, at which point they provide a promise. It may be verbal. Verbal contracts still stand just as written ones do, although of course they're harder to prove, aren't they? The promise is made to buy lunch and such. What are you putting fresh into the contract? You've already helped them. There's nothing else there. Next, an eccentric company owner decides to give away his company to me for free, provided I promise to retain the current staff. So I think here, in terms of this one, an eccentric owner decides to give away his company for free, provided I'm actually going to disagree with myself here. I'm going to correct that in a second, because I think the word free is a bit deceptive here. I think the word free is a bit deceptive, because we know that consideration has to have some value, but if we look at this, one party, the company owner, is saying that they will give away their company, but it's on the promise that current staff is kept. Therefore, the other party, who's going to receive this company, their promise here is going to be that they retain the staff. So what I'm trying to say is there is a sort of exchange of promises here, and I would say that has some value. So I am going to change that one in a second, I think, but the case can stay the same with respect to a promise that succeeds. And then lastly, before I do that, I promise to decorate my elderly grandmother's house in return for the property when she passes. And I was trying to sort of subtly make you think of the Mercadal case here, but the big difference is that this one works. I mean, we can distinguish it on the facts. They are materially different, because in Mercadal she had done it, she'd already performed that, executed it, whereas here you're promising to do it. So we're talking about executory kind of action. But I am going to change that one. I said I would, so excuse me 1 second. Yeah, there's always counter arguments, but I think that one is perhaps as clear as it needs to be. Right, okay, moving on. So yeah, bush. We just changed that one there. And what I would say with contract law, I mean, you do it across all three exam papers, crime and tort, but particularly for contract, I find, is that you have to, when you're looking at situations, the court could take a number of approaches to interpret situations differently, and there's always, what I'm trying to say, an argument perhaps raised by the examiner for you to spot, and you should really discuss both sides. But here I think these are pretty clear cut. We'll move on. So privity of contract is something, just to mention briefly. What does this rule mean? And this is really important, so try and sort of spot this in any problem scenarios as well. What it means here is that a person who is not a party to a contract, can't sue, and certainly cannot sue under it. They have no rights conferred to them from the contract. They are a third party, and I put that right at the bottom because this was seen as a sort of harsh rule, really. I know we've got other statutory legislation that kind of supports things like Consumer Rights Act 2015. If you buy a present for somebody and there's a fault with that present, maybe it's not of satisfactory quality, then you could see the potential problem here, because only the person who's bought the gift, who has that contractual relationship with, say, the retailer, the shop, can actually do anything about it. But I'm so glad that down here, as you can see where it says however, they try to redress the balance somewhat. So under the Contracts Rights of Third Parties Act 1999, there are measures where if you can provide the evidence to say, well, this clearly was meant to be for a third party, and perhaps, you know, by name or a gift and so on, then they will have some rights themselves and be considered part of that contract. I've not gone into any more detail about it here, but it's certainly something to look out for. So now we reach the last part for, you know, the essential elements of a contract in English law, and the last, as I see, is intention to create legal relations. What I like to ask my students at this point, because I kind of remember this back at, you know, when I was at school, I don't know about you, but I remember perhaps some parents trying to, you know, be particularly supportive of their children, and, you know, as they're about to sit GCSE exams, as we call it here. I remember one person, a friend of mine, he was offered something like, I don't know if it was 50 quid for an A grade, you know, 40 quid for a B, but you got varying things. And, you know, I think he was somebody actually at the time that wasn't really, you know, given past performance, was really never going to get an A grade. But I think it was seen as a way to sort of inspire, or, you know, aspire, I should say, to get those grades. But anyway, my point is here, your parent or parents tell you that if you achieve high grades in your college exams, they will pay you £100 for each of your 3 subjects. But however, when you actually get these grades, they refuse to pay. So the question I like to say here is, can you sue your parents or your parent? And some differing views on this one sometimes, I have to say. And the answer is, no. The answer is no, because in terms of intention to create legal relations, or the answer is, to be fair, the answer is no from the starting position. Let me explain. An intention to create legal relations means whether or not the contract is meant to be treated by both parties as, or the parties as, legally enforceable. You know, that it carries that weight, and should there be a dispute, it should go to court perhaps, or, you know, be dealt with that way through alternative dispute resolution possibly first. And so the common law has kind of identified 2 situations. We've got business agreements, which are usually binding, and then we have social agreements, which are not usually binding. They're sometimes referred to as well as you know, commercial agreements or domestic agreements, but I've put it as business and then social. However, what's interesting is that evidence can rebut these positions. And what I mean by that is, you know, take the last example where the parents refuse to pay when you pass your you know, A-levels or B-Techs with the grades that were kind of expected by them. We would constitute that as a social agreement. There is no action that you can take. How would you perhaps rebut that? Well, you could say, for example, if the agreement were written down, if it were dealt with in that more sort of formal way, and perhaps, you know, there was a signature or something, that again, that might be evidence that could reverse that. Perhaps if there were a great deal of money involved, that again would be something we'll see that could reverse that situation. And then obviously the opposite for business. The starting point is it will be, but evidence could reverse that. And I think the reason certainly that business agreements have more legal weight is because if you think about the sort of consequences, the repercussions of, you know, business agreements, contracts not being fulfilled, you're typically, not only are they carried out in a more formal manner, so that's something, of course, but if somebody, for instance, doesn't, you know, pay the amount that they were meant to pay, I mean, it could be big money that we're talking about here, and it could certainly threaten a business and its finances and the livelihood of all the people perhaps that it employs. So the consequences are far greater reaching. Now, two cases, probably two of the most famous contract law cases in existence. Good to actually compare and contrast. I think Balfour and Balfour was something like, off the top of my head, 1919, quite old. Merritt and Merritt, I think, was somewhere in the 60s. Why were these two cases treated differently by the courts? And they both involved sort of like a husband and wife. So with Balfour and Balfour, we've got here a husband working overseas agreed to send maintenance payments back home to his wife. When he stopped, she sued him. And if we look at the ratio, that's the one we're going to use perhaps for a social or domestic agreement is presumed not to be legally binding. So that's the case we'd like to use for that. Merritt, on the other hand, facts were the husband left his wife to live with another woman. Owing money on the house he owned with his ex-partner, he agreed to pay her £40 a month to help repay the mortgage and signed I think that's a typo there, and signed, I think that's meant to be an agreement that the house would be in her sole name. He later disputed the agreement. And though it was accepted that, again, husband and wife is a social or domestic agreement, if the courts could distinguish on the facts between the Balfour and Balfour precedent. So in other words, one side might argue Balfour and Balfour, that's the law, that's the precedent, that should be followed by this court. And the other side would argue, well, no, the facts here are materially different. And they were, because I think at least one of the key things here is in the Merritt case, the husband and wife had split up. And so immediately any agreement and such that they enter into would be treated more formally. And I can't remember with respect to this one, but certainly if anything had been signed to that effect, then again, more formal and would be treated differently, wouldn't it? So that would rebut the presumption of it having no legal intention to create legal relations. A few more cases here. I think possibly the last three for this essential element. We've got Jones and Padavatten, and you can see there the picture of the sort of unhappy daughter and the mother there. And the facts are a bit more detailed than this, but I've tried to summarise them. A mother promised to pay her daughter $200 a month if she gave up her well-paid job and went to London to study. I think she wanted her daughter, in fact, to become a barrister to study the bar. The mother, to fill in the bits anyway, I haven't put it there. I think after some persuasion, the daughter did do that, but she didn't realise, I think, that the $200 were not in United States dollars or anything like that, in the currency at least that she wanted. They were, I think, in Jamaican dollars or some such thing, so it was worth a lot less to her, and she was really struggling to kind of live from day to day, and she also had a daughter. So going back to the mum, the mother said, right, okay, I'm going to purchase a house for you where you can live with your daughter. And then what happened shortly thereafter is that the daughter, who was studying for the bar, stopped her studies, met somebody, and basically decided to take a different kind of direction with her life. And the mother then, very unhappy and such, but the mother then wanted to take the house back off them. And that's where the dispute arose. And here we've got consideration need not be adequate. I think in relation to this, I'm just going to check. I think the ratio on that one is not quite right. I'm going to have another look in a second, because I think with respect to, it's correct to say it need not be adequate, but in relation to this one, just understanding the position of the house. I don't know. Oh, yep, sorry about that. I paused for a minute because I just wanted to double check instead of trying to sort of guess that one. And I've made a little change. So if I go back, that was the facts we discussed, but the ratio here is just simply a domestic social agreement is not legally binding. So the reason I put that twice, because we've already got the ratio with sort of Balfour and Balfour, didn't we, on the previous slide, is that I noticed that sometimes this sort of situation comes up in an exam question, so it might be useful to learn. But if you want to drop one case potentially, just learn one for a domestic social agreement, and you could, as I say, go with Balfour. It's entirely up to you. Simpkins and Pays, now this quite interesting one, I have to say. It's got here: a grandmother, granddaughter and lodger entered a weekly competition, with the prize being money, and each of them took turns each week to pay to do this. And of course one of them got lucky, and the agreement initially had been that they would share this money, and of course the grandmother won and she refused to pay, and it went to court. And it was a question then of, was this again a social domestic agreement or something more? Should the money go to the lodger, and so on? And what we've got here is a social agreement can be rebutted with evidence. So I think here, with Simpkins and Pays, the point to be made is, where there is an exchange of money, and here, they took turns each week to pay, where there's an exchange of money, and certainly not an insignificant amount of money was won, I think the courts are likely to see that as evidence that this social/domestic agreement could be considered legally binding, to have an intention to create legal relations. And therefore the lodger and so forth did win. McGowan and Radio Buxton, so picture clues you can see there. And we've got here McGowan telephoned a radio station running this competition for I think it was a Renault Clio car. She won, and then when she went to collect her car, she was given a 4-inch toy vehicle. And of course what she didn't know is that the radio station was a bit of a prank joke radio station. They like to throw not very funny, but they like to do this, and that's what happened, and it caused much distress. Was she entitled to the car, or indeed for damages to get that car, or was the radio station entitled to do what they did? And the ratio here then is that a business agreement, for example a radio advertisement, which is essentially what this was, I suppose, for the competition, is legally binding. And you can see here from BBC News, I think the original news article from April 2001, she won £8,000 compensation, and I think quite right too, and she's quoted there as saying, "They used me as a gimmick and to try to get more listeners." And her and her daughter were very upset, but the happy ending there, and that she was able to put the money towards a new car. Right, so as ever, some more scenarios here, and now we're asking ourselves, is there an intention to create legal relations? Starting from the position of identify the situation as either business or social, and then knowing what you know, go with that. Pause the video if you would like, but we're about to go through the answers. Okay, so Alan agrees that he'll buy his son a book in return for mowing the lawn. We've got no intent to create legal relations here, because of course this is a social domestic agreement, and we would use that Balfour case. They are father and son. Secondly, James agrees to take his secretary Dawn out for a meal for finishing an urgent job quickly and at very short notice. Again, same thing, I'm afraid. Social agreement not enforceable, despite the fact that James and Dawn have this working relationship as well, and perhaps work in a business. It is clearly a social matter. Sanjay asks his daughter to give up her part-time job for a week to proofread a draft of a textbook, and promise to pay her the same as she would have earned in her job. I think I was certainly trying to draw a parallel here to the Jones and Padavatten case. We have, I'm afraid, no intent to create legal relations, much like that case. which involved the mother and the daughter, and that would be the same here. Mina, her daughter, and a neighbour decide to form a lottery syndicate and play each week, taking turns to pay. Mina wins £1,000 but refuses to share her winnings. Again, if this came up in the examiner would be, you're trying to draw a parallel to a case that you know, and I think you know the one I'm referring to. It's that Simpkins and Pays one, and given the exchange of money and the significant amount here as well, probably not a domestic agreement, as there's sufficient evidence for the court to accept that this should have, should be legally enforceable. Chris agrees to take his wife to the cinema, but fails to turn up because he had to stay longer at work. Unfortunately, sad to say for the wife at least, no intent to create legal relations. Again, it's a social domestic matter. And then we have Nazanin wins a competition for a house but finds out later that the house is in reality a playhouse for small children, and the competition did not refer to this. And again, you're probably ahead of me, but sort of parallels in a way to the last case of McGowan and Radio Buxton. This is a business commercial agreement and enforceable. That's most likely the position to be taken. Now, of course, with all these, evidence can, by one party, rebut, reverse the position, but as we didn't have anything else to go on, that's kind of where we are. I'm going to finish now by just having a quick look at an exam question, or at least part of it, given how early we are and the focus of this video on those two essential elements. We're looking at an AQA exam question, specimen 2016. It's part of a 30 marker, not the full thing. Molly knew that Lewis wanted to buy a second-hand refrigerator. She rang Lewis and told him she would sell hers for £90. Lewis suggested that he would pay £90 if she delivered it to his house. Molly said that she would think about it. When he had heard nothing further after 2 days, Lewis rang Molly and said he would pay £90 and collect the refrigerator himself. By that time, Molly had already sold the refrigerator to someone else. So I should have said always read the question first, and of course the question here, consider the rights and remedies of Lewis against Molly. What this simply means is Lewis will only have rights over Molly in contract law if we can establish a contract. And as this scenario seems to present to us, the two parties sort of negotiating, that's where our sort of dispute lies for this. And then consequently remedies, I don't think I'm really going to touch on that in this video yet, but could be seeking things like, for instance, not just damages, but maybe specific performance, forcing Molly to give him that fridge. So if you want to pause the video or plan an answer to this, I'm going to go through a sort of answer plan of sorts for now. So I think first to say it's a good type of question that illustrates that there are two views really working here. So if you have your highlighter pen, I think highlighting the key parts of the question, you're really line by line analysing and providing kind of analytical commentary on whether or not the elements of a contract are here. So if we go back remembering what they are: offer, acceptance, consideration, intention to create legal relations, then we want to make a comment for each and perhaps provide a case, legal authority, a case or a statute. So firstly, Molly rang Lewis and said she would sell the refrigerator for £90. You can say this is an offer by Molly, as the terms are certain, and she's certainly intending for that to be treated as one. And so the case we would use for offer would be Carlyle and Carbolic Smokeball Company Limited. An offer, of course, is a sort of proposition or proposal to another showing a willingness to contract, and can be to one party or indeed the entire world. Lewis suggested he'd pay £90 if she delivered it to his house, and we can say here this is a counter-offer by Lewis. He's not unconditionally accepting her offer, but he's rather saying, the courts might think, okay, I'll pay, but you've got to deliver it to my house. And we would look for a case for counter-offer, and I think Hyde and Wrench is the one that we want to use for that. Lastly here, Molly said she would think about it, and we can say certainly that there's no acceptance here. I mean, if earlier we've got an offer, that died, that offer, because Lewis has made a counter-offer. So So that's the one that's now in existence. The role of acceptance swings round to Molly. She has to say, yes to this or not, and she doesn't give it, does she? So basically what we can say here, if I give a case 2, Felthouse and Binley, that's a good case to support acceptance, and we know that acceptance can't be silence. Certainly it can't be, I'll think about it. We can see here that actually Lewis, under this viewpoint, has no rights, to bring to court, no contract that he could argue that he has with Molly. Now, that is not the end of it, because, as I said, view 2, interpretations, and the examiner would be expecting you to discuss both. On the other side, because otherwise, as I say, it would be a very short question, wouldn't it? But on the other side, if we start with, again, Molly rang Lewis, still an offer, okay, still the same case, but Lewis suggested he'd pay 90 if she delivered it to his house. Suggested. Might the courts look at this as a request for information by Lewis? Look, I'll pay 90, but would you kind of deliver it to my house as well? In which case our legal authority becomes Harvey and Facey to support the request for information. Molly said she would think about it. Well, we could say the courts might see this as a response to Lewis's earlier question. So, there's no acceptance here or anything like that. And again, same case. Then, when Lewis rang Molly and said he would pay 90 and collect the refrigerator himself, we could say, at that point, that's Lewis accepting Molly's original offer as put to him, unconditionally. He goes, right, okay, I'll pay it. No longer quibbling or asking anything about delivery. And we would use the same case for acceptance. When he hears nothing further after 2 days, this is where the examiner is expecting you to talk about, the issue of how long does an offer exist for? When does it cease to exist or be terminated after a lapse of time? And because nothing is specifically said, and I don't think we're dealing with, if it was like perishable goods. I mean, obviously, for example, I think if it was food that, could, go past its sell-by date and not have any value anymore. We're not dealing with anything like that. We're dealing with a fridge. So a reasonable amount of time, 2 days, it said, didn't it? 2 days. And I think that 2 days is more than enough in terms of being reasonable. I mean, if it was Lewis ringing up 6 weeks later, 4 months later, then the chances are no. But 2 days? No. I think that's fine. And the case we're going to use here is the Ramsgate Victoria Hotel and Montefiore case that dealt with that very issue, and that was the point of law, the ratio. And then finally, the refrigerator and £90. We just want to comment that that's consideration, and would be, wouldn't it, an exchange of promises, making it a bilateral contract. We could put in the Chappelle and Nestle case, couldn't we, about consideration being, what did we say earlier? Need not be adequate, but has to be sufficient. And I think, £90 would be, wouldn't it? Is there an intention to create legal relations here? I'm not sure if I put that here, but I think we'd probably accept that it's a business agreement. So under this interpretation, Lewis would be able to seek some remedies perhaps from the court because he could claim that there's a contract. I put it down there in the end. Would you believe it? So there we are. And the case, let's use McGowan and Radio Buxton. That was certainly a memorable one for business agreements. And that's the end, I think, of consideration, intention, create legal relations. Thank you very much for listening, and I hope you'll check out some of my other videos, as I'm going to try and finish the core topics or the substantive topics of contract law.